Time is 5:31. Good evening, board members, Mr. Santos, and district staff. On this day, the 18th day of December 2017, and I call this meeting, the United Independent School District Board of Trustees to order. Mr. Montemayor, could you please call roll?
Ricardo Molina,
Present.
Juan Roberto Ramirez,
Present?
Judd Gilpin,
Present.
and Mr. Ramiro Vélez.
Present.
I'm Javier Montemayor. You have a quorum.
Thank you, Mr. Montemayor. Let the record show that a quorum of board members is present, that this meeting has been duly called, and that notice of this meeting has been posted in accordance with Texas Open Meetings Act. At this time, I will turn the meeting over to trustee Javier Montemayor, who will preside over the first grievance. Thank you. Montemayor?
I think we need to make a motion. We're going to do this in open session?
Yes.
We're going to do this? This is the grievance. This is the level 3 grievance presentation of Paul Kane and Lina Volpe regarding the procedure used by the board trustees in conducting their prior level 3 appeals, which were considered by the board on October 11, 2017 and October 18, 2017, pursuant to UISD Board Policy Series DGBA. In accordance with UISD Board Policy, this grievance is being held before the United ISD Board of Trustees. My name is Javier Montemayor. May the other board members present please state their names for the record as to this grievance.
Ricardo Molina Sr.,
Juan Roberto Ramirez?
Judd Gilpin.
Ramiro Vélez III.
For the record, may the grievant and the district representative please introduce themselves at this time.
Tony Connors, I'm here on behalf of PFD members, Ms. Lope and Paul Kane.
Stephen Schroman Jr., I'm an attorney with the law firm of Jacobs and Associates, and I'll be representing on behalf of the district.
Very well. This grievance presentation, as well as the administrative response, will be open to the public at the request of the grievance. To provide a record of the proceedings, an audio recording is being made. Due to the bypassing of levels 1 and 2, there is no level 2 appeal record. Instead, the board has provided a board packet consisting of the following items. Number 1, the level 1 appeal filed by the grievance in this matter on October 25th, 2017. Number 2, United ISD Board Policy, DGBA Local and DGBA Legal. Number 3, the Level 3 Appeal Board Packet for Paul Kane's Level 3 Appeal filed August 25th, heard by the Board Subcommittee on October the 11th, 2017, and considered by the Board on October the 18th, 2017. The Level 3 Appeal Board Packet for Lina Volpe's Level 3 Appeal filed on September 11th, 2017, heard by the Board Subcommittee on October 11, 2017, and considered by the Board on October 18, 2017. A Court of Appeals Opinion Style Professional Association of College Educators versus El Paso County Community District, 678 Southwest 2nd 94, from the El Paso Court of Appeals, issued April 18, 1984. Number 6, Texas Education Code 11.1511. Number 7, Texas Education Code Section 11.1513. Number 8, Texas Government Code Section 617.005. Number 9, Article 1, Section 27 of the Texas Constitution. Number 10, Agenda Minutes from Board Subcommittee meeting held on October the 11th, 2017. Number 11, Agenda Minutes from Board meeting held October 18th, 2017. Number 12, the Level 3 Board script for the Board Subcommittee Appeal hearing of Paul Kane held on October 11th, 2017. Number 13, the Level 3 Board script for the Board Subcommittee Appeal hearing of Lina Volpe held on October 11, 2017. And number 14, the video recording of the October 18, 2017 board meeting. Number 15, the Board Subcommittee hearing transcript for Lina Volpe's Level 3 Appeal hearing on October 11, 2017. Number 16, the Board Subcommittee's recommendation regarding the Level 3 appeals of Paul Kane and Lina Volpe on October 11, 2017. And number 17, the video recording of the October 18, 2017 board meeting.
Mr. Montemayor, there's, Mr. Connors and I spoke today. There's a couple of things that he wants to introduce into the record, which are fine. One of them is a request that he had made previously to Mr. Ramirez when we had the hearing for Mr. Kane and Ms. Volpe, to have the full board hear it, and then the response that was issued by Mr. Ramirez. So those will be duly noted and placed in the record as well.
For the record, I have copies of it. And,
They're not part of the packet that we received.
No, but he'll give them to you right now.
Okay.
they're respectively Exhibit A, which is my email to board member Mr. Ramirez, dated August 30th, and then I have a letter from Juan Roberto Ramirez, board president, which I labeled Exhibit B. I'll give a copy to you and hand copy. You got it? Okay.
There's just one copy here.
I got it. Sorry.
Well, I can circulate this one. Thank you. This level 3 grievance is being conducted in accordance with DGBA local, the district's policy governing employee complaints, which is also included in the local record. I will now instruct the grievant and the district representative on the procedures to be followed in this grievance presentation as provided by DGBA local. The board will listen impartially to a presentation by both the grievance and the district representative. The grievance shall present first, followed by the district representative. Following both presentations, the board will consult with legal counsel Juan Cruz in closed session pursuant to 551.071 of the Texas Government Code. The rules for this level 3 grievance presentation are as follows. Only one person may speak at a time. Number 2, the grievance participants shall conduct themselves with common courtesy and respect for the rights of others. Number 3, the grievance and the district representative will each be afforded 15 minutes, which is a reasonable time limit to make their presentation. However, additional time may be afforded at the request of the grievant and the board president's discretion. If additional time is allotted to the grievance, the district representative will be afforded an equal amount of time. Number 4, the grievance and administration may not question the board. At the conclusion of both the grievance and the district representative presentations, the board shall consider the grievance complaint, and at that point, the board may ask questions of the grievance and district representative if necessary. The board may give notice of its decision orally or in writing at any time up to and including the next regularly scheduled board meeting. To provide a record of the proceedings and audio recordings being made, please avoid speaking when others are speaking so that the record will reflect the proceedings accurately. Are there any questions, Mr. Connor, Mr. Trump? I will now ask the grievance to proceed with their presentation. Mr. Connor, you have 15 minutes.
On behalf of the grievance I'll be presenting, this is exactly the way it should go. We're using your process to bring concerns that employees have before at least a quorum of the board. And we're not here today to relitigate or discuss the details of the earlier grievances, but I will provide you some information so you have an understanding briefly as to how we got here today. Well, Mr. Kane, he had a grievance over his reassignment, and his Volpe had a grievance over her summer pay, last year's summer pay. And we were hopeful and expected on the merits that we would resolve this at level 1 and level 2, because that historically has been the case. I've been coming here since '96 and probably come to the board maybe 8 to 10 times. That says that things are getting worked out. And we were hopeful that we'd work it out, but it didn't work out. And then we requested a hearing. We filed a level 3 hearing so that we could come before the board and get our 10, 15 minutes and have this thing heard and decided and move on. But they didn't get a hearing. Instead, over our objections, we were forced to have a hearing before only 3 board members in accordance with the current grievance policy, DGBA local, in which the 7 of you have delegated to the board president to decide whether there's going to be a normal board meeting or are they going to use a subcommittee. And I gave you at the start, Exhibit A and B is my letter that I sent to the board president, Mr. Ramirez, arguing that can we have the normal, can we have what the law requires, a board hearing? And he promptly responded to me and gave me his reasoning, and that is found on Exhibit B. So we were forced to have a hearing in front of 3 board members on October 11th. And we objected to that. But what turned out to be the most bizarre thing is the way it was conducted. It was conducted in ex parte fashion. That is, when we spoke, the other side wasn't present. When they spoke, we weren't present. And I recall that the chair of the board asked me how much time I wanted to save for rebuttal. I said, how can I have a rebuttal if I don't hear what the other guy says? Side says. It's like sending me to Neiman Marcus with $10 and telling me shop away. That's not proper. But after the subcommittee hearing, they came out and they voted to take no action and present the recommendation to the whole school board on October 18th. And that was handled in closed session. We weren't part of that party. We weren't in front of the board. Apparently, some of those committee members, they went ahead and discussed with you what they thought. And we had no idea. We didn't even know what the administration had to say. We didn't know what they were talking about when they were in there for 45 minutes plus. Had no idea until recently when we got the transcript, because we have appealed this to the Commissioner of Education pending. And apparently when you all came out of open session, you decided to take no action, which doesn't mean that the grievance is turned down. It's not until the next board meeting. If you all don't do anything, it has the impact of saying we lose. It's usually a polite way of saying don't thank you on your grievance. So we brought this appeal to the Commissioner of Education. It's pending. And I also brought this grievance because I wanted to come in front of the board and I wanted to talk to the board about the concerns. And we basically have 2 types of concerns. We have legal violation concerns and we have bad government concerns. So let's talk about the legal concerns. In the Texas Education Code, there are provisions that require the board to have a policy and process that allows people who work for the school district, students, even citizens, to have a hearing to come in front of the board, to present their grievances on the board. And those are found in sections 11.1511, subsection 13, and 11.1513, subsection I. And you guys didn't do that right. When we come before the subcommittee and we present our grievance in front of 3 of the subcommittee, we don't have a board hearing. Because a board only exists when you meet at a duly called meeting and you have at least a quorum. So going to a 3-board panel, that's not a board hearing. We also didn't have a hearing on the 18th. October 18th. We didn't come to you and present the grievance. We didn't have a hearing. It was these backdoor discussions with coming back out and giving us no idea what you all considered, what you decided. You just decided not to tell us, you decided to take no action. Now, the Texas Constitution, Article 1, Section 27, and the Texas Government Code, 617-005, they recognize the important right of public employees to bring grievances. And the courts have decided that means you're entitled to stop, look, and listen. You're entitled to an ear of government. but you're not entitled to a particular outcome. You're not even entitled to have a hearing in front of the board. In fact, the case is in the record, the El Paso Educator Association versus El Paso Community College. The El Paso Court of Appeals explicitly ruled that they weren't entitled to have a hearing from the Board of Trustees of that college. So why am I here? They got a winning case. And I'm telling you about their winning case. Because they don't have a winning case. That case does not discuss the education code, where the Texas Association of School Boards was very powerful. They realized how important it was for you to have hearings to decide important matters. That's why that case is distinguishable. But I know that Mr. Cruz is the senior partner of the firm, and he's your attorney, and he's going to advise you, and you're going to follow his advice. Of course you will. But that means that we're going to go to the commissioner, and we're going to go to the courts, and we'll see in the end who's right. So let's talk about bad government. Even if it's legal, bad government. Let me count the ways. First of all, as I said earlier, you only have power when you're at the meetings. And most of the information that you receive is what Mr. Santos and the administration chooses to have you hear. The grievances are one of the few times that you get to hear information firsthand, unfiltered, about important issues, about grading practices, about athletics, about all kinds of controversies. And you're elected by your community to have 1 to 7 votes. You should not yield your power to the board president in deciding who gets what, even if it's perfectly legal. You should hang on to your power so you can decide these important cases. Because if you don't, you give away your power, and there may be situations where there may be a 4-3 board on certain issues. And the board president could be in the minority, and he has the ability. I have no facts to accuse, I'm not accusing, but it's possible that the superintendent and board president can decide who will be on that panel. And it's altogether possible that a minority view will prevail in the panel decision. But that is bad government. And it sure isn't efficient. Is it efficient? No, it's not efficient because you got to meet twice. You got to bring your staff, you have the little subcommittees, then you come back again and you just discuss it in the meetings. That's twice. It's still wrong. It's twice. It's not efficient. Also, this ex parte thing, my gosh, that to me, I've been doing this since '87. I was a lawyer for school districts, 2 commissioners, for the past 23 years lawyer for public educators. I had never seen that ex parte. I was just beside myself. What is this? The last time I checked, we're on this side of the Rio Grande. What is this kind of plantation thing that you can't hear what the supervisor is saying? How can there be a hearing if you can't hear? How can that be a hearing? But one of the big problems is that there can be abuse. By standing next to the opposing side and being in the same room, that brings honesty, that brings accountability. So when we don't hear what they have to say, they may be saying things that we've never heard before. They may be saying things that are inflammatory and not true. And obviously they have a big influence because they're at the end of the train and this is the decision coming down. And we learned that happened in these cases. We learned in Ms. Lopez's case, they were coming up with a completely new rationale that we had never heard before. Didn't hear it in front of the transportation director's meeting, didn't hear it in mediation, didn't hear it in level 1, didn't hear it in level 2, and we surely didn't hear it in level 3 when we were in front of the subcommittee. We didn't hear about it until we got it after we filed this grievance and we filed an appeal. The same thing with Mr. Kane. Mr. Kane, they brought new information that we're not aware of. So, that's bad government. It's bad government. The citizens of United ISD and the constituents need to have better government than this. So, we're asking for what's in number 7 of the level 1. And I will own up that I made a mistake. There's a typo. I asked I think I wrote, it says on there, board subcommittee hearing. It should just be board hearing. That's what I meant. Obviously, I'm bringing agreements over to board subcommittee. But what we're asking for is, we'd like to we'd like to come back again the way it should have been, to let Mr. Kane and Ms. Volpe have their 15-minute presentation in front of the board, and you can decide. It may not change the outcome, but they want to have the satisfaction, at least coming all the way to the top, to have that done. And then we're asking that you change your policies and practices. You change your policy, your DGBA local, you change it to eliminate that subcommittee approach, and that you not engage in the practice of ex parte. Because I'm not aware of any district that's ever done ex parte, and only a few in rare circumstances use subcommittees. And because we recognize that we don't have monopoly on wisdom and solution, if there's something else to resolve this, we'd like to resolve this. We'd like to resolve this, and if we resolve this, we can not just resolve this grievance, but we can also resolve the pending 7057 appeal. So I thank you for giving this opportunity to present our important information, and hope that you all make a collective right decision, because you did take an oath of office that you would obey the law, and you also have a code of ethics that you will do what's fair and just. That you're not just about rubber stamping administration, and when you get into this kind of practices, you run into these problems. Well, thank you.
Mr. Troutman, you have 15 minutes.
Thank you. Good evening. For the record, my name is Stephen Troutman Jr., and I'm an attorney with the law firm of Jacobus & Associates. I will be presenting UISD's response to the grievance filed by Paul Kane and Lino Volpe on October 25th, 2017. This grievance stems from a Level 3 hearing that occurred on October 11th, 2017, before a board subcommittee composed of board members Ricardo Molina, Ramiro Vélez, and Javier Montemayor. At this October 11th, 2017 hearing, the board subcommittee heard the grievances of Paul Kane and Lino Volpe through their attorney, Tony Connors. The board subcommittee spent over 2 hours hearing and discussing these grievances. At the October 18th, 2017 board meeting, 2 agenda items were discussed pertaining to the recommendation of the board subcommittee in the matters of Paul Kane and Lino Volpe. No action was taken by the board pertaining to these grievances, which in essence upheld the Level 2 decision. This grievance was then filed on October 25th, 2017. In their grievance, the grievance claimed that their quote-unquote legal rights to have a hearing before the board to present our grievance were violated, and we were not treated fairly as far as our Level 3 appeals. The requested remedy sought by the grievance is as follows. I do know Mr. Connors stated he wrote the subcommittee as an error, but this is what it stated. Board subcommittee hearing to present our grievances and revising the district's current Level 3 practices and policies in order to comply with the law, as well as improve fairness and efficiency. We also request any other appropriate relief. First and foremost, as discussed above, the grievance were afforded a very long hearing before the board subcommittee on October 11, 2017, approximately 2 hours. If this was a mistake and the grievance are requesting a hearing before the entire board of trustees, which they are, there is nothing in district policy or the law that requires a hearing before the entire board of trustees. Board policy DGBA local, which governs employee complaints and grievances, that's the policy we're using today. I'm going to quote quite a bit from DGBA so we kind of know the process and the way the hearings were held. In DGBA local, board subcommittee is defined as a panel of 3 members of the board. DGBA local gives the board president discretion for either a board subcommittee or the board to hear and conduct a Level 3 grievance. Per DGBA local, and I quote, the same rules apply to a board subcommittee hearing and a hearing before the board. If a hearing is held before the board subcommittee, then the board subcommittee shall render a recommendation to the board at the next regularly scheduled board meeting. Board members shall not take part in any deliberations or decision-making without having first heard all the evidence. The presiding officer of the board subcommittee may set reasonable guidelines for the presentation, including an opportunity for the employee and administration to each make a presentation and provide rebuttal, and an opportunity for questioning by the board subcommittee. The The board subcommittee shall hear the complaint and may request that the administration provide an explanation for the decisions at the preceding levels. The board subcommittee shall prepare a separate record of the level 3 presentation. If a hearing was held before the subcommittee, they shall render a recommendation to the board at the next regularly scheduled board meeting. Upon such recommendation, the board may give notice of its decision orally or in writing at any time up to and including the next regularly scheduled board meeting. If the board does not make a decision regarding the complaint by the end of the next regularly scheduled meeting, the lack of response by the board upholds the administrative decision at level 2. End quote. Here, the district complied with board policy DGBA local by conducting the subcommittee hearing on October 11, 2017, and the discussions held at the October 18, 2017 regularly scheduled board meeting with the full board. The full board has provided an entire level 3 packet, or provided the entire record. The subcommittee strictly provides a recommendation. The board has provided a transcript of the hearings. They see what happens there. This is an efficient policy. It is good government. Regarding policy DGBA local, there's a legal reason that this policy is in place. First, Article 1, Section 27 of the Texas Constitution states, and I quote, "Employees shall have the right, in a peaceable manner, to assemble together for their common good and to apply to those invested with the power of government for redress of grievances or purposes by petition, address, or remonstrance." So the Texas Constitution does allow employees to grieve. In 1984, the Court of Appeals in El Paso, Texas, heard the following case: Professional Association of College Educators and James Simones versus El Paso County Community District, cause number 08-82-00353-CV. Here, this Professional Association of College Educators brought an action against the college's Board of Trustees, alleging that the board failed to respond to or consider a written grievance addressing a proposed change in the official policies of the college concerning the tenure of the faculty members. The Court of Appeals held that I quote, "We find no requirement that those trusted with the powers of government must negotiate or even respond to complaints filed by those being governed. But surely they must stop, look, and listen. They must consider the petition, address, or remonstrance." Close quote. Further, both the Attorney General in Opinion H-422 in 1974 and the Court of Appeals in Corpus Christi held, and I quote, "The right to present grievances is satisfied if employees have access to those in a position of authority to air their grievances. However, that authority is under no legal compulsion to take action to rectify the matter." Close quote. And for the record, that Corpus Christi case is Corpus Christi ISD versus Padilla, cause number 709 Southwest 2nd 700. So basically, in that case, you just have to be able to approach the board to address your grievance. That happened here. Board subcommittee heard the grievance, 3 board members. You all made a recommendation to the board where they had the entire board packet and all the evidence before them. Once again, this is efficient government. Here, the board satisfied all legal requirements by conducting its board subcommittee hearing in accordance with DGBA local on October 11th, 2017. The grievance had the opportunity to air their grievance to those in a position of authority, as 3 board members were present, and both the board and the board subcommittee considered the grievance, which satisfied the stop, look, and listen requirement. The law basically states that school districts should have a complaint policy, but it does not in any way govern or outline how the process or procedure to hear complaints should be conducted by a school board. So long as there is a complaint procedure that allows employees to present their employment complaints, there is no further legal obligation imposed on the district. As such, board policy DGBA local satisfied all necessary legal requirements pertaining to employee grievances, and the district has complied with the law and its own policy pertaining to Paul Kane and Lina Horta's grievances. For these reasons, I respectfully request that the grievance requested remedy be denied. Thank you.
Does anyone have any questions for either of the parties?
If we set the meetings up the way we have, and a 4th board member or 5th, multiple board members show up, then that's in violation of the property posting meeting, correct?
Yes, but we do post those meetings in compliance with the act.
So people would have the option of attend, just the question of whether or not we proceed with only 3 according to the policy or more board members show up.
Correct.
So I guess there wouldn't be any harm in having board board member that, it's about the same as a regular meeting. If the board member doesn't choose to show up, then we don't choose to show up.
Correct.
But we would be out of the situation where if we get down to 3 people, we can't have the meeting.
Yeah.
It's kind of interesting that it actually worked that way. So we could actually have enough board members to constitute a quorum, but we really wouldn't actually be having a board meeting. I guess that's because we're not making a decision.
Right, and that's exactly the way we set up the business and instructional committee meetings. We post them in compliance with the act, so that if there's 3 or 4 more members, and on occasion there may be, you all can sit in.
So as long as a decision isn't being reached at that time, we could have as many board members present.
Yeah.
Okay. And I guess the other part of this is, as far as the legalities of it, it sounds to me like actually both parties probably realize that it's probably legal. But the only way that will really be tested is if we move forward with it and it goes to TEA and they confirm that it is in fact a legal way to proceed.
I'm not even sure that TA, to be honest, would have jurisdiction over this, because this is a government code and Texas Constitution issue, and when you have government code and constitutional issues, the commissioner does not have jurisdiction over that. It may be straight into a court of law.
Gotcha. So there'd be extra cost and whatnot
Correct.
associated with that.
For the record, Alicia Oliveros is now present in the meeting. Any other questions for either side? Mr. Vedder?
No, sir.
Okay, thank you for your presentations. At this time, the board will adjourn into closed session pursuant to 551.071, 551.074, 551.082, and 551.0821 of the Texas Government Code to consult with legal counsel regarding the outstanding grievances of Mr. Kane, Ms. Volpe, and to hear the outstanding grievances of parents MB on behalf of TB, parents AC on behalf of LC, and Marilyn Bryce, Thelma Cavazos, Linda Garza, and Claudia Villarreal. The time is now 6:03. We are in closed session.
We convene from closed session. The time is 10:05, and the board will take appropriate action on items, if necessary, as discussed in closed session. Item number 4A, is there a motion to take action regarding employment grievance of Paul Kane and Linda Volpe presented?
Yes, I move to amend the board policy to require every grievance hearing to be posted in compliance with the Texas Open Meetings Act in order to allow for all board members to attend as necessary. Further, my motion is to allow both parties to be present at the time of the board hearing. However, the board will reserve the right to excuse one party out of the hearing based upon the conduct of parties and issues involved in the grievance.
Is there a second?
Second.
Any discussion? All those in favor? Motion passes. Number 4, item 4B, is there a motion to take action regarding employment grievances of Marilyn Bryce, Thelma Cavazos, Linda Garza, and Claudia Villarreal as presented?
I move to deny the grievance remedies requested.
Is there a second?
Second.
Is there any discussion? All those in favor? Motion passes. 4C, is there a motion to take action regarding parent-student grievances of LC?
Yes, sir. Regarding the Level 3 F&G appeal of Parent AC on behalf of Student LC, I move to deny all requested remedies with the exception of the quiz taken on May 9, 2017.
Is there a second?
I second.
Any discussion? All those in favor? Motion passes.
There's one abstention.
Mr. Rodriguez abstains?
Abstain.
You too? Okay, abstains. Mr. Molina and Mr. Rodriguez abstain. Is there a motion to take action regarding parent students grievances of TB as presented?
Yes, sir. Regarding the Level 3 F&G appeal of Parent MB on behalf of Student TB, I move to deny all requested remedies with the exception of the quiz taken on May 9, 2017.
Is there a second?
Second.
Any discussion? All those in favor? Mr. Rodriguez abstains. Motion carries.
Mr. Molina abstained.
Mr. Molina abstain?
Yes, sir.
Mr. Molina and Mr. Rodriguez abstain. Motion carries. Agenda item 5, adjourn.
So move.
Is there a second? Any discussion? All those in favor? Motion passes.